Hey, can everybody hear me? I'm not sure if this microphone is working. It seems to be. Well, welcome everyone to breakout session B, which is the duties of an offshore company or nominee director. Are they held to a lesser standard? My name is Simon Dickson. I'm a partner at Mourant, Ozannes in the Cayman Islands, where my particular focus is on insolvency and restructuring. I'm delighted to share the platform with two distinguished speakers this afternoon, Claire Robey and Ken Krys. Claire has a CV that would put most of us in this room to shame. She's a barrister specializing in international commercial litigation, asset tracing, insolvency and company law. She read law at Oxford, obtaining the highest first in her year, and then went on to do the BCL before practicing at the bar in London. She moved to the BVI in 2008, and now she's a lawyer at Harneys, where she's appeared in a number of high-profile cases, including Westford Special Situations Fund Limited and Barfield Nominees. She is also one of the contributing editors to Harneys' book on BVI commercial law and has written and spoken widely on the subject. With a first-class degree from Oxford, I'm sure she won't mind if Ken and I pass on the more difficult questions to her. Ken, of course, needs little introduction. He's a licensed insolvency practitioner and the founder and CEO of Krys Global, which has offices in Cayman, the BVI, Bahamas, Bermuda, and Guernsey. Ken has been involved in a number of high-profile cases over the years, including BCCI, Sphinx, and Fairfield Sentry. In a former life, Ken was the head of compliance at the Cayman Islands Monetary Authority, and he's also a keen ultra-marathon runner and started the off-the-beaten-track trail run in the Cayman Islands. I wonder if we could close the door before we go too much further to try and keep the noise out. Thank you. All right, so moving on to the business of the day, we're going to look at the duties of an offshore company and nominee directors and ask the question whether they're held to a lesser standard. So for the next 15 minutes or so, I'm going to talk about the duties of directors of English and Cayman companies. I'm going to talk about the key differences between the English and Cayman regime. I'm going to talk about possible developments in the Cayman Islands. Then Claire is going to discuss the position in the BVI and some recent decisions in the BVI and the Cayman Islands. And then we're going to conclude with Ken, who is going to discuss practical issues a liquidator encounters with directors of an offshore company. Okay, so turning to the duties of a director, I think broadly speaking that the message that I have is that the duties owed by directors of Cayman companies and those owed by directors of English companies are broadly the same. And for the sake of convenience, we can break them down into three categories, namely fiduciary duties, duties of care and skill, and other statutory duties. Well, we're all familiar with the concept of fiduciary duties. Directors are in a position of trust vis-à-vis their companies, and accordingly they owe those companies fiduciary duties, which are essentially duties of honesty and good faith. Now, prior to the Companies Act 2006, the position in England and Cayman was essentially the same, in that the duties arose under the English common law, which for all intents and purposes the Cayman Islands adopted. In England, however, the duties of directors were codified by sections 171 to 177 of the Companies Act, as set out on the slide. Now, in most respects, codification has not altered the underlying common law duties. Indeed, section 178 of the Act says that a breach under the company's law is the same as would apply if the corresponding common law rule or equitable principle applied, which is perhaps proof, if proof were needed, that codification has done little to modify the common law position. It's fair to note that codification has changed some of the duties slightly. For example, the codified duty to promote the success of the company is arguably more prescriptive than the common law position has been. However, aside from some relatively superficial changes, the position in England under the Companies Act and the position in Cayman remains practically the same. Now, there is some debate in Cayman as to whether the director's duties should be codified. And it could be argued that by codifying directors' duties, it would bring clarity and it would improve standards of corporate government. governance rather. In my view, this is something of a red herring. It should be remembered that we're dealing with settled concepts and that any director, and in particular a professional director, should be very familiar with the issues, and we live in an age where guidance on duties is easily and quickly obtainable. I think it should also be remembered that duties of directors have evolved over the years due to careful consideration of the changing commercial context. In my view, these changes are much better left to the commercial court, which is familiar with the business and the context in which these duties are discharged, as opposed to Parliament or the legislative, which has less practical experience and doesn't have the luxury of dealing with these issues on a case-by-case basis. Turning then to duties of care and skill, or skill and care, depending which way you want to put it. I think most of us in the room will be familiar with the City Equitable case and what is set out there as what the requisite common law duty of skill and care is. I mean, these duties are pretty much the same as those discussed by Mr. Justice Jones in his Weavering judgment some 87 years on from the City case, and Claire will deal with Weavering in a moment. However, the Weavering judgment is an ample demonstration that the common law position in Cayman is the same as the common law position in England. And again, as with fiduciary duties, the care and skill duty is also codified, and again, in my view, the codification does not alter the previously understood common law position, although there might be some debate about that. Moving on then quickly to other statutory duties. There are statutory duties in England and Cayman which differ in some respects, but many go to the same issues, such as the duty to keep statutory books and records, duties in respect of payments of capital, duties arising out of insolvency proceedings, and there are also other duties, such as duties arising under the anti-money laundering regime, under the corruption law, under the data protection law. So where does this leave us? If the position is that legal duties owed by a Cayman director are the same as in England, is there then a separate lesser standard to be applied in the Cayman Islands when dealing with what are termed nominee directors? The answer to that question, in my view, is emphatically no, because as a matter of Cayman Islands law, there's no such thing as a nominee director. The expression nominee director has different connotations depending on the business context. For example, a director appointed to represent the viewpoint of a substantial shareholder or a company's bankers may be described as a nominee director. However, the duties owed by that director would not differ from those of a normal director. And in the context of this session, nominee is an even more loaded term, in that it applies that someone has agreed to act wholly on the instructions of, say, an investment manager, without any regard to the duties and responsibilities owed to the company, and in that respect is the other person's nominee. Now, I'm not aware of any common law jurisdiction in which the role and responsibilities of a director are at all compatible with the concept of being someone's nominee. Therefore, anyone offering to act as a nominee on the basis that there is some lesser standard to be applied to them will be quickly disabused of that position should the company fail and their actions come to be examined. And I would be extremely surprised in the wake of a fund failure if I was faced with a professional director who sought to run such a defence. Given the focus on corporate governance in the offshore jurisdiction post-2008, given the publicity generated by the Weavering case, any director who felt he was in some way justified in not adhering to the strict legal standards of a director by virtue of being a director of a Cayman company will, to my mind, have acted in an extremely foolish manner. So if the duties of a director are the same in England as in Cayman and the concept of a nominee director does not exist, is there any argument to say that directors of offshore companies are held to a lesser standard? And I think it's fair to say that there are probably two areas where it can be argued not that directors are held to a lesser standard, but rather the regime in the Cayman Islands affords directors greater protections than in England. The first is the indemnity provision, and the second is the lack of a mechanism for directors' disqualification. Now, turning to indemnities, in England since 1948, companies have not been able to exempt or indemnify their directors from liability for negligence, default, breach of duty, or breach of trust. And the prohibition is, of course, subject to certain relaxations. In Cayman, the position remains that companies may indemnify or exempt their directors for any failures other than fraud, dishonesty, willful neglect, and willful default. And this is probably the most significant practical difference between the two jurisdictions, given that it affects the company's prospects of recovering from its directors in the event of their negligence. The argument with which we're all familiar is that by allowing such indemnities, directors are not kept on their toes and therefore discharge their duties to a lower standard than their counterparts in England or other countries where indemnities are not allowed. This argument is often repeated, but I'm not sure that there is sufficient evidence to support it such that it becomes fact. Indemnity or no indemnity, every jurisdiction will find instances where directors have failed in their role, and so the various instances where these failings are exposed cannot necessarily be linked to the indemnity provision. And the argument also fails to take into account the commercial reality of the situation, especially when we come to look at professional directors. It suggests that professional directors, because of the indemnity provisions, are content in their daily professional lives to provide a subpar service. Again, there's little evidence of this, indeed quite to the contrary. In my experience, those providing such services do so with expertise and set high standards that one would expect. Any other model would be commercially disastrous. The argument also fails to take into account the whole anti-money laundering framework in which Cayman operates. The idea that a professional director would be less than assiduous in attending to his duties because of an indemnity ignores the other potentially more serious consequences a director may face if he finds that the fund or company of which he is a director and of which he has paid little regard is involved in some sort of criminal activity. All directors seek to protect themselves from personal liability, be it through insurance or by taking advantage of an indemnity. And therefore I put it no higher than this, but I will say I'm yet to be convinced that directors seeking protection from personal liability can necessarily, or the fact rather, of directors seeking protection from personal liability can be linked to poor corporate governance standards in the modern age. In terms of directors' disqualification, we've gone on one too quickly, this is an area where Cayman is lagging behind. In England, of course, it's possible for a court to disqualify a director under the Company Directors Disqualification Act 1986. In Cayman, there's no such legislation, and this is an area which, in my view, needs to be reformed. At present, the monetary authority can substitute a director of a registered fund if it finds the director is not a fit and proper person. However, where a company is not required to be registered with CIMA, even this small protection falls away. The difficulty with not having disqualification legislation is that the bad apples are not prevented from continuing to ply their trade, and this leads to increased reputational risk and, importantly, increased risk to investors. So, what does the future hold in Cayman? And the answer to that at the moment is the consultation paper put forward by CIMA on the 14th of January 2013. And the consultation paper proposes various changes to the law. It proposes, first of all, that not just professional directors providing their services through corporations are required to register with CIMA with full disclosure of any regulatory, legal or judicial actions against that director. The creation of a public database containing the details of all directors. A change in the law such that directors of 6 or more Cayman Islands entities must seek permission to act or be offered as a director. To update and amend the statement of guidance to establish principles by which a board of directors can operate, and CIMA have also instructed Ernst & Young to conduct a survey with a view to considering whether a cap should be placed on directorships held. Well, as you might imagine, this consultation paper has triggered a pretty furious debate, and indeed so far it's attracted judicial review proceedings in respect of the manner in which the consultation process has been carried out. So what are the issues arising from the CIMA proposals? Well, in respect of the registration of all directors, this seems to me to be a sensible move and closes what is a loophole in the law. The creation of a public database, however, has caused some concerns. And the reason for this, in some respects, is that there is no mention in the CIMA paper, or indeed in many of the reports on secrecy in the Cayman Islands, of the transparency and requirements under our mutual fund law requiring an offering document to be provided to investors containing all information in relation to an offering, such as would enable an investor to make an informed decision, including the names and the details of the directors. The argument goes that given investors in the Cayman Islands are invariably high net worth individuals or institutions, it can be assumed that they undertake extensive due diligence before investing, although I'm not sure that that necessarily follows through. The argument continues that it follows that armed with this information, any prospective investor can make full inquiry of the fund as to the directors, as to the director's position, as to the number of directorships held by any director, and determine whether to invest or not. So when we are faced with articles such as that in the Financial Times on the 29th of April, suggesting that large institutions are frustrated at the lack of transparency in respect of directorships held, it does seem, or the argument goes, it does seem an odd complaint in that they have the power before investing in finding out any information in relation to the directors of that fund or indeed anything else in the offering memorandum that concerns them. And if they aren't happy with those answers, they're under no obligation to invest and can vote with their feet. So that is the argument. That is the argument against a public database in one respect, suggesting that it's not necessary. In my view, it seems to me to be hard to justify not having a public database that allows access to that sort of information by interested investors, unless there is some reason, there's a reason I can't think of at the moment, but there is some reason why access to that information would either be detrimental to the investors or detrimental to the fund industry in the Cayman Islands. Moving on to the permission to act point, this perhaps is a more legitimate concern in respect of a move to amend the law to provide for pre-approval process of directors of 6 or more entities. It's entirely unclear how this would work, but what would be damaging to the industry is to find that there is a laborious bureaucratic process which requires on a case-by-case basis directors who hold directorships in more than 6 entities to be approved on each and every occasion. It would cut across one of the main attractions of the Cayman setup, which is the speed with which funds can be created. And so that is an issue or a point put forward by CIMA which does require very serious consideration. The attempts to update the statement of guidance, again, this is a laudable objective, and I would have thought in theory no one could have any objection to it. The difficulty at present is that it's unclear how it will work, what the effect of the guidelines are, and how CIMA will monitor them, and whether they're designed to establish a regime distinct from the current law. And the reason I say that is because the guidance notes, or the contemplated guidance notes, do not follow the common law position. For example, they require a director to have the ultimate responsibility for effectively managing the affairs of a regulated entity. And that's inconsistent with the actual duties as confirmed under Weavering, which allows a director, by way of permitted delegation, to take on a supervisory role only. So if there is to be an updated statement of guidance, then it needs to be put in context, and directors need to understand how it fits into the current regime and with what sanctions. And most importantly, directors must be clearly advised if the statement of guidance seeks to amend and extend their existing duties under the common law. And finally, the hottest topic is a survey being conducted in relation to the number of directorships held. The issue seems, both from a reputational perspective and a corporate governance perspective, to be one that will need to be addressed. The problem for those who are not familiar is the argument that certain professional directors may hold hundreds of positions on boards and therefore cannot discharge their duties properly. Whilst in principle it seems to make sense to try and deal with this issue, it is by no means a straightforward task. Much depends on the type of company and structure within which that company sits as to how many directorships are required and how much attention each company requires. It also depends on the organisation providing the services and the systems in place within that organisation as to whether a higher or lower number of directorships are appropriate. In my view, there's no fair way of introducing a mandatory cap, putting an arbitrary figure on the number of directorships held. Instead, if this is a route that CIMA proposed to take, it would seem sensible to me to introduce a figure above which a review process is put in place, whereby CIMA can approve an increase in the base level of directorships. So in conclusion then, from a Cayman Islands perspective, I would conclude by making the following points. Number one, there is no lesser legal standard for a director, however styled, in the Cayman Islands than there is in England. Number two, directors may rely on an indemnity in the Cayman Islands and not in England. However, for the reasons set out, I don't believe there's sufficient evidence to necessarily support absolutely the argument that this lessens standards. There is a gap in the law in that there's no mechanism for directors' disqualification. and in my view, this is a change that is long overdue. Finally, despite what many may think, Cayman is not an island. It conducts business in all major financial jurisdictions in the world and is alive to the issues in Cayman and internationally concerning corporate government and alive to the needs and concerns of investors. It is important that Cayman keeps up, and it's important that those in charge of dealing with corporate governance make sure that the changes will in fact work and that we do not find that we introduce regulation merely to bend to current political will. And with that in mind, I'll hand over to Claire.
Thanks, Simon. Can I just check that my microphone's working? Everyone can hear me at the back? I think that's a no. That's any better? The sound turned up, perhaps? No? All right, I'll use this one. Is it working now? I'll take you. Is that one working? Can I be heard now? Yeah? Has everyone got me? Great, thanks. So thanks, Simon. And I'm going to use a lot of what Simon started out by saying in relation to the fiduciary and other duties of directors as a basis for my section of the presentation. In particular, I'm going to look at the scope of directors' managerial duties, and I'm going to do that by looking at two cases, one from Cayman, which is the Weavering decision, with which many of you are going to be familiar, and one from the BVI, which is locally known as the Spectacular decision. Now, this discussion does come with a bit of a health warning in that both of those cases are under appeal. Weavering, so far as I know, has already been heard, but no decision handed down. And I understand that Spectacular is just getting going on appeal. So this talk, given in a year's time, could well be radically different. And the second health warning is that both of the judgments are perhaps more fact-sensitive than you would usually find for a normal standard judgment. Now, it's important to bear in mind that what I'm addressing is the issue of whether you can narrow the scope of the management duties which a director undertakes. I'm not looking at the question and not saying that you can remove fiduciary duties. So even if there is a more limited scope of managerial duties, for those tasks which the director does undertake, there's no question that the high standards of fiduciary responsibility will still apply. Now, as Simon has set out, there are several sources of those directors' duties. In the BVI, those have been largely codified in the BVI Business Companies Act. You have the duty to act honestly and in good faith and in the best interests of the company, to act for a proper purpose and not contravening the M&As, and to take care, the care, skill and diligence of a reasonable director. Those are, of course, supplemented by the common law fiduciary duties, which Simon has just taken us through, such as not to make a secret profit, not to act in conflict of interest. Those will also be backed up by the contractual duties, if any contractual or directorship agreements have been entered into, and of course the tortious duty of care, which is to exercise the reasonable standard of care. So in answering the question of what is the scope of a director's managerial duty, some would say potentially there is a difference between Cayman and the BVI, and a high-level summary, which is, as you will see, one that I would disagree with, and I'll come on to that in a moment. A high-level summary might be that the Weavering case says that you cannot strip away a director's management duties even if the director is unpaid. You just simply can't do that. In contrast, the Spectacular decision says a UBO may dilute some of the managerial duties of a director. Now, as I'm hopefully going to demonstrate, I think that's too high level and too abstract and too simplistic a conclusion. I'm going to argue that they are more similar than you think, the two cases, and in fact, mostly consistent with each other, and indeed, of course, the onshore position, as it's set out in England and Wales. And interestingly, in one aspect, the Cayman position imposes potentially a higher standard than the onshore position in England. So I'm going to take the cases in turn, give you, for those of you who aren't aware, some factual background and the circumstances surrounding it, and go through the judgment fairly quickly. I'll take Weavering first. So this was a Cayman fund entered into interest rate swaps. It was listed on the Irish Stock Exchange, which is a very important fact. Now, as well as the usual service providers, there were two directors. There was also an investment manager, which was indirectly owned by the bad guy, a Mr. Peterson. And handily enough, the two directors were in fact his elderly stepfather and his younger brother. And they, for all of their trouble in the end, were paid no fees in accepting these directorships. The fund was put into liquidation after the professional service providers all discovered that a large number of the assets were in fact fictitious. Claims were understandably brought against the directors by the liquidators. And the facts of the case and the lack of supervision undertaken by the directors is really quite astonishing with hindsight. They never held proper board meetings. They were found by the judge to have fabricated certain of the notes of the board meetings, and they really made no attempt whatsoever to look at the commercial realities of the transactions. So the judgment held that they had, of course, breached their duties, and in particular, these directors were criticised for being what the judge described as automatons. And he held very clearly, and as Simon has mentioned, it's a very lengthy judgment which sets out in great detail, particularly in the investment fund's context, what is expected of your directors, and it's a lot. So each individual director owes duties to inform himself about the company's affairs and join with its co-directors in supervising and controlling the company's affairs. Although he may delegate some functions to other professionals, he cannot exclude his supervisory duties. And he has a duty to acquire a full understanding of the financial results of the investment and trading activity, because absent that, he can't really regulate it properly. And in that regard, there is no difference whatsoever with the English onshore position. Indeed, the court relied on a large number of English authorities in reaching this conclusion. And really what was underlying it all, in my view, is that there's a duty to satisfy, for the director to satisfy himself that the investment manager's strategy is fairly described in the offering documents and that the IM is complying with whatever he said he's going to do. And essentially, it's to make sure that the fund is not misleading its subscribers. So that's the Weavering decision. The Spectacular decision is a first instance decision of Justice Bannister in the BVI Commercial Division of the High Court. This is factually very different. The two cases are poles apart. Now, whereas you had a regulated investment fund in Weavering with, I think, 27 shareholders at least, many of whom were institutional, Spectacular involved a sole UBO of a BVI company. That was the BVI company was called Spectacular. The BVI Incorporator, which was Sitco, provided a sole BVI director, which itself was a company and not an individual. Now, the UBO here deliberately had no direct contact with the director, and he structured the arrangement in this way. He used an intermediary through whom all of his instructions were given. Now, this all went along fine until, of course, inevitably the UBO and the intermediary fell out over what the intermediary said was some of his unpaid fees. And at that point, the intermediary caused a power of attorney to be granted, which he then used to enter into a sale purchase agreement for a sale of the company's sole asset, which is a property, I believe in Brazil. And it was at a fairly large undervalue, with the proceeds to be paid to the intermediary for his missing back pay, he said. Now, the sale was eventually unwound, but not without some significant losses to the company, at which point the UBO caused the company to bring the claims against the director. Now, something to bear in mind about this case is that this was only a claim brought in tort, partly because the contractual claim was arguably statute barred, and even if it wasn't, it could well have been very difficult because the UBO had refused to sign up to the management agreement with Citco and the corporate director. Now, the BVI Commercial Court found that the directors did not breach the duties that they had undertaken in the context and on these specific facts. And the judge relied on the English, again, the onshore position, in finding that there's nothing unusual, onshore or offshore, in there being a division of managerial responsibility between a UBO and the board of directors. Now, in assessing that on the facts, the judge, of course, found it very important to assess that in the whole circumstances of the case. And this was a situation where the UBO had deliberately structured this so that the directors would act on occasion on his instructions. And as long as the UBO's instructions did not involve dishonesty, fraud, or illegality, the court held that the directors were entitled to rely on them. And indeed, the court went on to say that had the directors set about challenging the minutiae of the day-to-day decisions and the commercial wisdom of what the UBO had asked them to do, for example, independently valuing the sale of the property and then sending the UBO a bill for it, the UBO would have been appalled and would probably have quite rightly hit the roof. So some people have said that there are potentially some legal differences between these two positions. And the contrary argument to this is the one that I'm going to set out now, that these are actually factual differences which give rise to the different outcomes. And in my opinion, putting the argument at its high watermark, there are 5 key factual differences which could be said to have led to the different outcomes. Now, the first issue is the one of regulation. This is a funds case versus a non-funds case. Now, funds naturally and obviously need to be more regulated. This was listed on the Irish Stock Exchange, as part of which the rules require 2 independent directors. And it was repeated throughout the Weavering decision that the duties which the judge is describing and setting out are duties relating to an investment fund. He's very clear about that. And of course, there are many shareholders in a hedge fund context, or at least one would hope so. And you contrast that with the Spectacular decision, where there was a sole UBO. He was the one who had put in place the very structures that he had complained about being abused. So the court's view was that he had taken on the risk of allowing the intermediary to have power and to remove some of the management decisions from the directors. So that's the first factual difference that could be argued to have amounted for the difference in outcome. The second one relates to the issue of the fees paid to the directors. Now, in Weavering, the directors, for all of their trouble, were paid absolutely nothing, and yet they were still found to be liable to, I believe, the tune of $111 million. The liquidators suggested in arguments that this demonstrated that the directors never intended to do any work, and the court agreed with that. Now that, interestingly, imposes a higher standard than in England, where the Barings PLC line of cases say that you can actually look at the level of fees which are paid in determining the scope of a director's responsibility. If you pay them less, you can expect less of them. And the English courts onshore have sanctioned that approach. And indeed, that's exactly what happened in the Spectacular case. The court took note of the fact that the director was paid a relatively small amount, and the court went on to say that for that amount per year, you simply cannot have expected the directors to delve through every single decision, commercial or otherwise. So perhaps there's an argument there that the onshore world might want to take a look at the Cayman position on fees. The third factual difference is the subjective element relating to the experience of the directors. Now, this is the subjective test where the directors are assessed by the experience that they actually possess. In Weavering, the offering memorandum held out the extensive experience that these two directors actually possessed. So although they weren't actually exercising this, they did have the qualifications and expertise. In particular, the stepfather who had 35 years of very high-level investment experience. And this, of course, being something in the OM, is something on which the investors would no doubt rely when deciding whether or not to enter into the fund. The fourth issue is really a technical legal one. It's fairly brief. It's the issue of admissions. In Weavering, the directors admitted that they had a high-level supervisory role. So it was never really open to the court to find that the director's duties had been significantly reduced. And the fifth and final one is the issue of wrongdoing and where the real wrongdoing lay in each of the cases. Now, I'm not suggesting that either of the judges looked for where the wrongdoing was and then moulded the law to fit. But as we all know, where the wrongdoing lies is going to be at the back of a judge's mind. And it's certainly going to subconsciously guide perhaps the flavour and the overall approach to a judgment. And in my opinion, in both of the cases, the decision quite correctly placed the liability where the wrongdoing lay. In Weavering, the wrongdoing was on the part of Peterson, and the court disliked the fact that his family members were essentially lending their names to lure the investors in, so it found against them. Similarly, in Spectacular, the UBO admitted that he had set up this structure as part of a tax avoidance scheme in Brazil by using a company to cover his beneficial ownership. So in that context, it's unsurprising that the BVI court was unwilling to assist him. And as an aside, having ventured into that territory, which is somewhat outside the scope of today's panel discussion, if anybody is thinking of trying to take what I've just said as an example of how the BVI can be used to assist in tax evasion, I would point out that the arrangement that the UBO used in Spectacular was hardly the most complicated one. He simply used the corporate veil, which is a device used both offshore and on, and not one which is horrendously complicated. I'm sure we're all very familiar with that. And of course, where it's used wrongly, courts have the power, quite rightly, to pierce the corporate veil. So to conclude, I would say that the two decisions are actually more similar than many people have perhaps considered. And they can be distilled down, the similarities can be distilled down to four very important principles, and they are these. First of all, that you cannot qualify fiduciary duties. Secondly, that you can, in appropriate cases, split managerial responsibility. Thirdly, however, whether you have successfully done so depends on the circumstances of each case, and the factors to be considered there will be things such as the governing documents, the contractual structure, what's been held out to third parties, and the regulatory position. And fourthly and finally, even if you do pare down or split your managerial duties, directors can never exonerate themselves from acting dishonestly or illegally simply by saying, the UBO told me to do it. So on that note, I'm going to hand over to Ken, who's going to talk, I understand, about directors' duties from a liquidator's perspective.
Thanks, Claire. All right, so we'll move away from sort of the legalese of all of this and what are the huge standards and high standards in Cayman and BVI and talk about some of the practicalities of what liquidators and fraud investigators look into in regards to the question of going after directors. You would have thought there was such a number of high standards in Cayman and BVI, and with the fair number of liquidations that happen, that we'd be suing directors left, right, and center. That actually doesn't occur. Quite honestly, when I get first brought into a job, I don't spend a lot of time worrying about whether a director is a nominee. I actually struggled for a long time. I had to go and look on Google to find out what actually a nominee director is supposed to be, because I've actually never sort of spit it and thought about it that way. You got sort of the idea of a nominee as somebody who sort of takes instructions from the ultimate beneficial owner, and presumably only signs when they get instructions to do so. Have it done under some sort of power of attorney or some sort of other authority. There's a question about whether, even if you have directors that are relatively passive and don't do much than sort of attend annual meetings, whether those people are nominees. I can't tell the difference between one and the other. So we don't spend a lot of time sitting and talking about whether directors are nominees or not. It's actually a little bit more complicated than that, as to trying to decide on whether you go against a director or not. There is, clearly when we first get in, we actually try to be friends with the directors. Directors have a couple of important things when we go in and over an appointment. One is that we need them. They have ongoing duties and responsibilities. They do tend to have some knowledge. They can assist in regards to giving us the balance sheet or where the assets are. They may have access to information. So there are certain duties and obligations that we keep in trust. In the case of one of the funds that I'm involved in, we've kept a good relationship with what I would call the more passive directors for a number of years. And it may be something where we need to use them for a particular matter that we need, in which, if you go back to the offering or to the memorandum and articles of association, there's a question of whether, A, the directors have the authority and are the only ones that can do it, or whether I, as a liquidator, haven't taken control of that company, have that authority that's been brought on to me. But keeping a relationship with the directors may allow me to be able to do the things that I need to do. They also have duties in regards to retention of records and assisting in that regard, which can be depending on what has been copied in on them and what they may have access and kept in their files and that type of thing. So there are, from our point of view, a lot of things that you look at, whether it's a full director, a nominee director, an executive director, a non-executive director, whatever people want to sort of call them. Deciding whether to pursue a director is not a simple question. I understand what Claire said, that understandably the liquidators pursued the directors. It's actually, it can tend to be quite a complex type of decision-making process. Numerous things go into the question about whether we will go after a director, or whether we think it's worthwhile pursuing a director. And a lot of it will also depend on where we pursue that director. Clearly there are a lot of things that are in relation to Cayman and BVI companies regarding the things or the standards that they are held to. But in some instances, we may decide that Cayman and BVI is not the place to sue them. And then it's a question of really whether in those jurisdictions, let's take the United States as a good example, whether the United States will actually apply the standards that are in the Cayman Islands or BVI, or whether it will apply its own standards. And also whether there are certain public policy issues that it deals with on things like indemnities. So when you're going and directors are when you're going to decide whether you're going to go after a director or not, while you will take into considerations the duties and the obligations and the standards that they have in Cayman and BVI, you also will be looking at other jurisdictions as well. In my experience, just because there's been a huge fraud doesn't mean that there's been nominee directors involved. You can have quite legitimate directors or quite active directors involved as well. So that's not usually a telltale sign. Some of the things that we'll look at is trying to figure out where the director has assets. That tends to be a relatively important aspect of whether you're going to pursue the directors or not. And a lot of reasons why directors probably are not pursued is because they don't have sizable assets or they don't have the necessary insurance. And if they don't have insurance and they don't have assets, that means costs going out and not a recovery coming in, unless there's some good strategic reason to have them in. The other thing is that if you're going to be pursuing some of the other deep pockets that are out there, for instance, if you're going to target the auditors, if you're going to look at maybe the investment manager in the case of funds, if you're going to be looking at financial institutions, either for potential clawback claims or whatever else, it may not make a lot of sense to sue the director as well, particularly if you're going to be pursuing some of those actions in Commonwealth countries or in the United States. They've got this awful defense called imperi delicto in New York, which basically says that if the core of the company is bad, which is usually looks at the question of whether directors have complied with their duties and were fraudulent as well, then it's difficult to pursue other cases pursue cases against other third parties for what losses may arise from the wrongs. I've seen this in cases that I've been involved in, and clearly there's been a number of other cases. New York has held, or that the imperi delicto is a very strong defense that parties can use. And so the question you may be sitting down and asking is, who do I dislike, or who's going to be more likely to be able to fill the coffers for investors and creditors or the stakeholders? And is it better to go after a financial institution or somebody with a deeper pocket rather than a director? And that may help you in regards to being able to provide certain evidence somewhere down the line, particularly if you can ask the question of, if you had known that there's fraud had occurred in your institution or had been highlighted and brought to your attention, what would you have done? And the best person to ask that question is the director. And if you haven't tainted that director too badly by suing them or anything like that, they can provide an answer that will assist you in regards to your legal proceedings. So the question of whether you're going to go after a director or not can be tied into the question of whether there's a deep pocket. The other thing you'll be looking at is what we call low-hanging fruit, which are the easy recoveries to bring in. My experience, director claims are not easy. You have, particularly in the offshore, and particularly in the Caribbean, the question of the indemnities. Those of you who are familiar with Cayman and particularly familiar with the Sphinx case, indemnities has been an absolute nightmare in me being able to distribute assets on that estate. I'm sitting on about $500 million. I've been sitting on it way too long. And the biggest issue that we have to try to decide on, besides compromising the various stakes and interests, which they've now done through a scheme, is to decide how much money to set aside in relation to indemnities. Indemnities you would have thought was easy. It's an indemnity for them to make their claims. But I have figured out that indemnities are extremely complex and can be made up of a number of dynamics. They can reclaim their costs. They can reclaim their liability if they're sued by the institution and put a claim in for that. They can put one in on the idea that they may be sued by a third party. Or even worse, if you sue a number of defendants, the idea that one of the defendants will get a judgment against them and sue that your indemnified party. We are currently in the process of trying to quantify that amount. I suspect it will be very large. The judge or the court has already ordered that $117 million be set aside just for costs in regards to indemnities against various parties, including the directors, which is a very sizable amount of money. Other things you're going to be looking at is where there's been activity in regards to the director, where they've been, where they did their business meetings, where they may have marketed themselves. You'll also be looking at the question of costs. Clearly, the benefit of looking in places like the United States is they have contingency fees. Whether a contingency fee attorney makes sense to bring in may mean that it's going to be cheaper to be able to pursue that case, whereas in the offshore, and particularly in BVI and Cayman, you can't retain attorneys there on a contingency basis. You may have to be worried about adverse cost orders. Again, that's something you don't get in the States, but you may end up dealing with in the offshore world. And so those are things that you will take in as well. You also will look at some of your legal remedies. It may not be necessary for me to prove a fraud a particular party. Aid and abetting is a nice little term that can be used in regards to pursuing certain parties. And nominees you can bring in under that. I don't necessarily need to show that they were directors. So there's a number of things that when I go in as a liquidator, I'll spend time trying to figure out, but it's more usually around the facts of the case. It's usually around whether I think that I can meet some of the thresholds in regards to the indemnities, or whether there's a way out of it. In the case of Sphinx, where I have this large indemnity reserve that started with the cost, and we'll see if it increases after that. What we did in that case is there's a number of those that are subject to indemnities, either that are pursuant to Cayman law or subject to memorandum and articles of association. What we did is rejected those. They were appealed, but those are pending what happens in United States litigation. So I've been able to sort of change it a little bit from it being argued in Cayman as to whether it's a valid indemnity or not, and tried to put it in front of a jury in the U.S. court, who will have to take into consideration Cayman law, but will also have its own public policy views on the question of indemnities.
Okay, can I just stop there? Can you explain how you did that? Because that's quite an important thing to try and get it shifted from Cayman to the U.S.
Yeah, well, what we did in that case was the liquidation is in Cayman, so we had parties come in and filed the proof of debts at the same time as I had done, or before that, I had actually pursued those parties also in the United States, in New York court. And so when they made their claims in effect saying, you've sued us, we want to make a claim for our legal costs that we've incurred, for any liability that may arise, and for anything else that may be caught by the indemnity. I made a decision to reject those claims. I'm basically arguing that in the United States I had argued that they were fraudulent, that they were negligent, that they had breached a number of terms, and it was quite a detailed analysis, in effect replicating a lot of what had been argued in the complaint in the United States. That had been appealed, and the question really became where was the best place to argue that appeal? And we argued that that matter was already in front of the U.S. courts. The question about whether they're liability or not shouldn't have to be re-argued in the Cayman courts. It would be a duplication of fees. It would be take significant time, and particularly it may sidetrack the litigation that was in the United States that was very important to our underlying investors and creditors. And since Cayman recognized the United Court as very competent in being able to decide on this matter, that they would be best equipped to be able to deal with the question or not of liability, and then that the Cayman court would in effect take that into consideration in determining whether the appeal should go through or not. So that basically allowed us to minimize the cost, but it also changed the reflection on who actually is looking at the question of the liability, in that case against some directors, and then how the indemnity will be dealt with. It's turned out so far we'll be in trial later on, I think start of next year, so we'll see how that works out. The other things that will be, we also look at, as I said, was whether there are assets or not. Insurance you have to be careful with. There's usually, in my experience, isn't significant amount of insurance that's out there for directors. So unless that's the case, that may not be your source of assets. I've also found that directors aren't exactly, in a number of cases, usually aren't deep pockets. The ultimate beneficial owner may be, but to the extent that it's a corporation or, they normally dividend out their assets every year, and they don't normally sit on a large amount of cash or whatever else. So really whether it makes it worthwhile, particularly given legal costs that you may incur and the standards that you may have to express or to be able to get, really questions whether you pursue those parties. But those are some of the practical things that we look at in regards to nominee directors.
Super. Okay, well, thank you very much, Ken and Claire. I mean, I think the conclusion that I draw from what's been said today is that the position really is that the legal standards, both in the BVI and Cayman for directors, are high, although I'm not sure that Ken necessarily agrees with that. But they are high from a legal standpoint, and that they're very similar to those on the onshore, in the onshore jurisdictions. And perhaps the issue that we need to struggle with is that when funds collapse and when the behavior of directors comes to be judged against these standards, very often the position is that there isn't sufficient, or there are not sufficient assets or sufficient insurance to properly pursue those directors. And that perhaps brings into play the issue of regulation to try and ensure that these sort of collapses are not necessarily the result of the actions of directors. So with that in mind, I'm going to take this microphone off so I'm not the one answering the questions, but are there any questions? Yes. So certainly in Cayman there's been no deviation from the usual rule. I don't know what the position is in the Ken, we'll look to you for the US.
I have no idea. I'm not a U.S. attorney.
Very well. Nothing that we're aware of, I think, is the answer to that question. Anyone else? No? Great. Well, if there's nothing else, and I think that's probably a relief to the three of us, that nobody's contradicting absolutely what we said, we'll call time, and thank you all very much for attending and for giving us your attention.